Well, hello and welcome back. This is our second video in the farm succession, transition, estate planning opportunities and resources that Kit Tovar Jensen and myself, Guido Vanderhoven, are putting together for your use. Today's topic is in Kit's wheelhouse. It's farm succession planning basics and terminology, looking at the legal structures and what do some of those mean. And we welcome you and hope that this would be a useful resource to you to use in your planning process. We do have a disclaimer. We as employees of CALT do not provide any legal or tax advice, as you can see there. And the presentation as Kit has prepared it is intended for educational purposes. And we are looking at our experience. We work together, and these are our conclusions and recommendations. And obviously, they don't necessarily reflect the views of Iowa State University.
Yeah, thanks, Guido. Thanks everyone for being here. We're watching it from wherever you are. And so we do receive a lot of questions from producers on estate planning and farm succession planning. And many are looking to understand this somewhat complicated process. And in this video, we're going to go over just some basic terminology used in estate planning. And if you want to follow along, the slides are available for download below. And I'm also going to link to that first video where Guido discusses 10 common farm succession planning mistakes to avoid. But just to get started, before we jump into the more technical aspect of it, I want us to be thinking about why do people avoid estate planning? And here are some of the more common issues that come up that are things and opinions that people will tell me. And that's, first off, we don't need a will. Our family knows what we want. And well, that's all fine and good if you think you can trust your family, and a lot of people get along great with their family. But the issue comes up with intestate laws, and we'll see that how if there is no will, if there's no trust, and no type of succession planning tool, then the court system, they have to follow laws based on the state that they're in to distribute property. And other people will say, well, we don't need a will because we made one years ago and we don't need to update again. We don't want to think about it anymore. And that's kind of a mistake too, because, well, life changes, right? Laws changes, rules change, regulations. And besides that, well, family dynamics change, right? There can be marriages, death, divorces, birth, a lot of different things come into play. So we want to be aware that we talked about this in our first video. We are always being flexible and realizing that things could change, and this is not a one and done type of situation. And another reason I'll hear why people don't think they need to do estate planning anymore is because, well, they don't need any type of estate plan. They want all their kids just to get equal shares. 3 kids, 1/3 goes to each, but that really doesn't take into account things like sweat equity, where one child has stayed on to farm, has given up a career somewhere else, has sacrificed salaries to stay home. And there are tools out there, there are options to take that into account if that's a goal of yours, to make things more equitable. And again, this is we talked about goals in our first video, and it's so important to think of what our goals are. So what is at stake? Why do we have these estate plans? And I have a picture of the Buckingham Palace here, and it seems like the royal family, they're always in the news about something, and they are a family that has very high stakes to make sure that their assets stay in the family, their power transition all goes smoothly, right? They have a lot to be thinking about. But at the same time, when Queen Elizabeth first became queen, I don't know if anyone could have anticipated that she would be queen for 50 years now, and that there would be the future generations there and waiting. And so even people who have a lot of stake, who have a lot to plan for, things like that, plans can change. And so we need to be aware of that. And so I want to move a little bit closer to home now. We talked about the UK. We're going to be looking now at, this is my grandparents' family farm in Western Iowa. A lot of you watching this are probably from Iowa or have some connection to the state. And this just because the Rowe family has a lot of stakes, so do a lot of us with family farming operations. You're working with your family, and things do change for us too, right here. If you look at this picture, farming has changed so much, right? We don't have machinery that looks quite like that anymore. The ground isn't quite torn up like that anymore. We don't even dress like that anymore. Things have changed, and as well as not just life has changed in society, but also rules have changed, and culture as well, where it used to be the oldest son would get everything and get the whole farm, and the other siblings just had to make do with what they could. And that's not exactly how things work anymore. So we want to be flexible and also communicating to our family and our estate planners what our goals are and what we're thinking about. So today, farm succession planning today, really the purpose of what we're talking about is we're going to look at a lot of different tools, but also what just works best for you, for your family, for your operation. And there's really no one size fits all option. There's pros and cons to each of these, and they are some of these that people will choose to incorporate is one, they'll create a business structure, and that could be a LLC, a partnership, a corporation. There's all sorts of different things like that. There's also such a thing as testate distribution, and so that's done through wills. Some people use a will and create in those wills an option to lease, an option to buy farmland, anything like that. Trusts are also becoming more common, and we'll look at those. And gifting is a little bit different than the rest of these, where gifting is used whilst a person's still alive, but it still can be a very important part of the entire farm succession plan that an operation uses. And then finally, some people, maybe all of the above is the right answer for you, because farm succession planning, these tools, I like to think of it like a buffet. There's a lot of different options here, and maybe just one flavor is right for you or one tool, but maybe it's a couple different ones, and it might look different. What your table or family dinner looks like than someone else's, and so your estate plan might look different than another person's. And it isn't just a, there's no broiler templates of here's your estate plan for a farm. It's so unique and personalized that that's why we want to talk about all these different tools and kind of the purposes behind them. But to start off, we'll look at probate versus non-probate assets. And probate is a word that you all probably heard a lot of. And all that it is just the legal process to transfer assets at the time of death. So it's how assets are transferred through the court. And probate, so any probate assets that are passed through a will, that will go through the court system, and as well as intestacy. If someone dies without a will, without any type of a without any type of a succession plan, they will die what's called intestate, and that also goes through the court system to distribute the property to the proper beneficiaries. There are some exceptions for smaller estates, but that's not as common with farming operations. There's also non-probate assets as well that we'll look at next. One of the big ones that a lot of people should look into is life insurance. And that's just a contract between the person buying the life insurance and the company. And so that normally won't go through the court system. Also, joint assets with right of survivorship. Those are also non-probate assets. And the important thing to distinguish here is that this is not something like co-tenants where a couple siblings own farmland together as co-tenants. That would not qualify here, but it's something, joint assets with rights to survivorship, where maybe spouses own land, or in joint tenancy, maybe they have a bank account together, something like that. That would also be a non-probate asset. Retirement accounts don't go through probate, as well as trusts. Trusts are just distributed according to the trust document, however the person setting it up made it. So let's look at next at intestacy. And like I already mentioned it before, but intestacy is just someone who passes away without a will or a trust or anything like that. And interestingly, that's about half of the US population. I don't know if that quite correlates to the farming community and the agriculture industry, but there could be some of you watching this who this is the first time you've thought about it, and you're just trying to figure out where to even begin. And intestacy, it's sometimes called an estate plan by default, because states have created laws that they are trying to figure out what a person would likely do after they pass away if they had a will. And so they do this based on degrees of kinship. So the closer you are related, that's who they prioritize to be a beneficiary of your assets. And for example, in Iowa, if you're married and you die intestate, everything goes to your spouse. If you are not married but you have kids, everything will go to your kids. And so it kind of starts closer, and eventually it goes further up to parents, siblings, grandparents, aunts and uncles. And if the court can't locate any family, the assets will eventually what's called escheat to the state. So it will, the state will become the beneficiary if there's nobody else. And so that some of you might be thinking, well, is that really that bad? But intestacy is, the state's trying to do it the best they can, but it doesn't take into account a lot of common situations that we have today, like second marriages or blended families, where people are very close with their step families and want to include them in their estate plan, or even family-like relationships. We've talked to producers who maybe they don't have children or family around, but they're very close with their neighbor, and they have a parent-child-like relationship with them, and they would like to leave everything with them. Intestacy would not take that into account. And even though this topic of estate planning and succession planning, it can be uncomfortable. We're talking about death and finances, but it really is important for even, for the next generation to have these things figured out, because there's also kind of issues with if you have a minor child or minor children, if you don't have a guardian designated for them, if both parents pass away, well, then that has to go through the court system to figure out who's the best guardian for that child. And we want to make sure we're not using intestacy as a backup plan, because we want to have things be as smooth as possible for our family. So we'll move on next to testate distribution. This is almost the opposite of intestacy, where you do have a will. And so what a will is, and we all know it, but it's just a legal document that lets you distribute your property after you pass away, how you would like to do that. And wills, they're complicated, and we encourage people to work with an attorney, with tax professionals when setting up wills or trust or anything like that. But at the basics of it, what you need for a will, and this is for Iowa, it might differ slightly depending on what state you're in, but in Iowa, to have a valid will, it just needs to be in writing. So at this point, you can't do a video will or anything like that. It has to be in writing. The testator, the person creating the will, they have to sign it. There also has to be 2 witnesses. And so those 3 are the technical requirements. But there's also this issue of testamentary capacity. There has to be, the testator has to have this capacity to make, this mental capacity to make a will. And that's actually one of the most common issues that comes up, is not so much the first 3 technical requirements, but was there testamentary capacity? And what testamentary capacity just means is, like I said, do they have the ability to make a will? And courts, when they're trying to understand this, because it does come up so often, did that person making the will, did they have testamentary capacity? What they look at is, did the testator, did they understand the nature of the document? Do they know that this was a will and that's what they were signing? Do they understand the nature and extent of their property? So do they understand what they own? And it doesn't have to be exact. You don't have to know the exact acres of land you own or the exact amount of money in your bank account. But just, is there anything strange going on where they're trying to put something in their will, some type of asset that is not theirs, that kind of was a red flag. They also will look at, does this testator, do they understand the natural objects of your affection? Are they naming beneficiaries that make sense? And now this doesn't mean that you have to include your children in a will. You can actually disinherit pretty much anyone except your spouse. But what they're looking for here, again, is there any red flags that make it seem like they did not have the ability to understand what was going on? And also, does the testator understand the effect of this disposition, that this is going to give away their property once they pass away? And there really is no time like the present when it comes to making a will, because as time goes on and a person starts to get older, that's just welcoming in more types of challenges to a person's testamentary capacity. And there's no age requirement or anything like that. There's really no type of test or anything you can take to show you have testamentary capacity. But an attorney may take extra precautions just in they may want to show that they truly do believe that this person has testamentary capacity. So they may ask questions: what year is it? Who's the president? They may even film to show that there really was no concerns despite some later challenges that comes up. And this also really shows how important it is to communicate too, because when people are not expecting a will or trust to be created the way it was and different beneficiaries named, or how a will distributes property, and they might think it's unfair, there might be some will challenges. And this really is a common challenge, is the testamentary capacity, because it comes up mostly, we see it in what's called undue influence, where a third party unduly influenced the testator to change their will because that testator had a lack of testamentary capacity and they could be influenced. So I want to illustrate this with a case that came out a few years ago in Iowa, where there was 3 siblings, and they brought this lawsuit after their father passed away, that their brother had unduly influenced their dad to enter into below market rate farmland leases with their brother. Their dad, who was also a farmer, had gifted land to their brother. And because what had going on here is that their dad and their brother had farmed together for many years. And so they said that this wasn't fair, basically, that their brother must have unduly influenced their dad to change things. But at the time, Iowa law defined a vulnerable elder as someone who's over 60 years old and can't protect themselves because of their age or a mental or physical condition. So this is what they're basically claiming here. And the Iowa Supreme Court, they said, well, no, that's not how ages alone is not enough to show that a person is a vulnerable elder. You also have to show that there's some type of inability to self-protect. So when they looked at this case, was there any type of mental or physical disability? And they looked at medical records, and the farmer who had passed away, he had normal memory, normal cognitive function. There was no type of evidence that he had any lapse in judgment because of his a mental or physical issue. And besides just the medical records, there's also more practical evidence where this farmer, he had been closer to 90, but he had recently been reissued a driver's license. He had continued to manage his own finances during this time, and he'd even served as the executor of his wife's estate and as a township trustee during this time when he was making these gifts. So because of that, the court found there was no lack of testamentary capacity. The will was valid. There was no undue influence. But I think also we need to be just reminded that the siblings were maybe a little bit surprised that they more went to their brother than they thought. So communicating with your family about your wishes, as uncomfortable as it might be, can show that you do have you know what you're doing, and this is intentional. We also have trust then. That's another type of will substitute, and they can sound somewhat complicated. We have this roadmap here of all these different things that you need for a trust. And but when you get down to the basics of it, what does a trust document that creates the trust have to have? Well, first off, you have to have a trustee. That's just the person who's managing the trust asset. And you also have to have that trust asset, right? That's called the corpus, or the body of the trust. And that can really range from a wide variety of different things. It can be a land, it can be stocks, it can be just money. There's a lot of different things that could be a trust body, a trust asset. And as well as there has to be beneficiaries. So the person who is receiving the benefit of the trust, either an income off the trust, or they'll actually eventually receive the trust asset sometime, those are the beneficiaries. Now, what are some of the advantages of trust? And one of the big ones is that a trust can separate the assets and by that the management of the trust or from the trust asset from the beneficiaries. So that just means that sometimes some people are not as interested in certain things like a farming operation, but putting land into a trust, well, someone else can manage it. They don't have to, and they can still receive income from it. This can also look and appear in different ways too, where you can utilize professional management services, and that can show if you have stocks or some types of investments. Maybe you want someone who has a high knowledge of taxes and finances to be managing it instead of you. So you can use someone else's expertise while still you have ownership of the asset through the trust. Trust can also minimize probate costs because you won't be going through the probate process at all. So there's less fees and attorney's fees, court costs that go along with that. Trust can also provide different types of requirements to transfer property to either a minor child or someone, a family member with disabilities. And you can set these up for in a lot of different ways. Trust can be used maybe even if you have college students and you would like to help them with tuition for 4 years, and then when they're 25, 35, 45, whatever age you set, then they can have complete access to the asset. Then they will get, you set these different stipulations for control of the asset. There's also more privacy through a trust compared to a will, because with a will, since you're going to the court process of probate, there is it's public record. And so with trust, they're not public records, so people can't know your exact assets or how much of it. There's also sometimes there's a thought that there is a increased protections from will contests, like the one we just saw, where that undue influence, and that's the hope of trust, that they're they're created during life in a lot of instances, and it will prevent any type of fighting in the family. But at the same time, trust can be very complicated, just like wills, and they can the fights can become very complicated and more expensive as well. So there's a few different types of trust that we're going to look at here. That first one is called the inter vivos or a living trust. And like the name sounds, it's established while a person's still alive. And these types of living trusts, they can either be revocable, where they can be changed, or irrevocable, where they cannot. And there's also testamentary trust, where they are created by a will when someone passes away. And there can also be pour-over wills, where when someone passes away, a trust will be established at the time of death through some type of residual asset. There's also charitable remainder trusts and life insurance trust. There's a lot of different types of trust depending on your goals. So first off, let's look at these revocable trusts. And one of the main reasons they're so popular is because they are very flexible. The beneficiaries can be changed, the document can be changed, all these different things. You're not losing complete control of the asset, and you get to retain this control. But one of the biggest issues that comes with a revocable trust is what's called failing to fund the trust. And this just means that, for example, if you had land in a trust, well, the land needs to be retitled with the in the trust name. So we have to make sure that's happening, that it's not just the document being made, that property is actually transferred into a trust. We can't forget to do that. And again, that's why it's so important to work with a professional to make sure little issues like this are avoided. So here's some of the advantages that why people like to use revocable trusts. And one of them is avoiding ancillary probate. And ancillary probate just, it comes with when there's property owned in multiple states, real property owned in multiple states. So for example, if you own a farm in Iowa and then have a vacation home in Florida, well, instead of personal property where it's subject to the probate and will and trust laws of the state where the person passes away, real property, it's going to be under the jurisdiction of the state that it's in for probate purposes. And This that just mean that a little bit extra work where you maybe hire another attorney. There's more court costs and things like that. So it's not as simple. And that's another reason that people do like revocable trust, is because it does simplify settling a estate after someone passes away. There could be less costs. Just because things have been set up, bills have been, the trustee should have been maintaining the trust assets throughout the life of the grantor, the person who created the trust. Assets are more easily available because probate can be a slow process. I think the average time it takes to set up get through the probate process for it to settle an estate is maybe 2 years. Trust can do that much faster. There's also trust provide what we'll call easier, seamless property management. And that's just as someone gets older, or if there's some type of accident or any issues that come up, well, the trust is owned and it can be managed by the trustee, the successor trustee. There's already a plan in place if somebody can no longer manage that asset. And irrevocable trust now, well, the main difference between that and revocable is that you are giving up all control and power of an asset when it's placed into an irrevocable trust. So whatever that may be. And there are some reasons to use them, but we have to remember that when you transfer something, a property or asset, into an irrevocable trust, it is then a completed gift. So it cannot be taken out of the trust, and there can be different types of federal gift tax concerns. If you're gifting over the amount, there could be forms to fill out, and it's something, again, to talk about with your tax advisor, making sure that you're not exceeding any limit and being aware of the federal estate tax. Irrevocable trusts, they're often used to reach a specific estate planning goal. For example, in this first one, for those who have a family member with a disability, some sort of disability, a special needs trust could be an option for you. And these types of trusts, they can be used for a person who would qualify for a government program, and you want to make sure that the asset in the trust is not included in that beneficiary's income. Now, spendthrift trusts, they're also pretty similar, and they can be used to help a family member or a beneficiary who really, they're a spendthrift and they're their own worst enemy. An asset in a spendthrift trust, it can't be touched by creditors generally. So, but at the same time, any income off the trust can go into to the chosen beneficiary. And one thing to be aware of for this third one then is that for Medicaid applicants, there is a 5-year look back during the asset portion of the application. And we want to be aware of that if that's something that you're looking into. Then also, irrevocable trust can be used to reduce a person's taxable estate. There is currently an $11.7 million lifetime exclusion. And what that means is just that the first $11.7 million per person is not included, does not count towards the federal estate tax. Most estates, they don't have any issue with that. They don't hit that limit, and it's double that limit for married couples, but it is still out there. So Guido, am I missing anything else here?
Kit, I think you've hit it for the introductory purposes, and I like these three that you illustrate here: the special needs, the spendthrift, and also the caution looking at the for the Medicaid back, the 5-year look back or 60-month look back. It's really depending on which document you look at and you read. And yes, we do have 11.7 million. That's for 2021, which is the lifetime gift exclusion. So if we create a trust and it happens to be an irrevocable trust, we can actually move up to 11.7 million into that trust, utilize that gift exclusion amount. There won't be any gift tax, but you've got 11.7 million that was moved into the trust. So I think you've covered most of it, Kit.
Mm-hmm. Yeah, that, and it does have its use, the irrevocable trust, but it's something you don't want to just rush into. You understand all the impacts of it, especially with the loss of control that you're going to have. So thanks, Guido. There's also a testamentary trust, which like we talked about, they're triggered at death, and they're created by the terms that are described in a will. And one of the main advantages of a testamentary trust is that you get to retain complete control and complete ownership of an asset until you pass away. And then the asset can be transferred into a trust. And so this can be used to manage assets for minors. You can think of an example where parents, they don't want their minor children to have access to certain assets until they become old enough to, they're mature enough to use the property responsibly. So they may hold the property for themselves, but their will say that, well, at this age, the child can have this much, and then at this, 10 years later, they can have the rest of the asset. Testamentary trusts, there also can be used for special needs and trust and spendthrift trust again. These are another way to create them through a will rather than during your life. One thing, so we talked briefly about who you disinheriting children and who has to be in your will. And one thing that in Iowa, it's very hard to disinherit your spouse, because in Iowa, we have what's called the 1/3 elective share. And that means that if for some reason your spouse is not named in a trust or will, they're usually going to have a right to 1/3 of all the assets in that trust or will. And the only way that a spouse can be disinherited is with a valid prenuptial agreement. If they, before marriage, a couple has created a prenup, then that's okay. But the reason behind this, we want to make sure no one's accidentally ever disinherited, especially a spouse. Because we've seen cases where someone with farmland creates a will in their 20s or 30s, and but doesn't get married till their 40s or 50s, and they just never think to update their will and add their spouse in it. And this goes to show that we need to make sure we're being aware of our beneficiary designations and updating our will as life changes, as it does. And so we want to make sure that spouse could still have receive something that they probably would have. In Iowa as well, though, the law says that a spouse is going to be written out of a will or trust, though, if there is a divorce. So that could be different. If you're watching this from a different state, that could be different, but that's the rule in Iowa. But then, so one of our last things to talk about is beneficiary designations. And this is a little bit different. It's not quite a tool, but it's something that we want to talk about. This term, what does it mean? What does it do? Because there are going to be a lot of issues that come up with it. And beneficiary designations are prevalent in everything, right? In life insurance, retirement accounts, if your state has transfer on death accounts, trust wills, what we just mentioned, those all have beneficiary designations, right? But one of the biggest issues that comes up is people don't name a beneficiary. And this can be maybe you didn't realize that your retirement account could have one, or you just didn't think to ever set it up. You didn't, just forgot. And that's why I really encourage people to every year check to make sure that your beneficiary designations are up to date. This shouldn't take long. It shouldn't have changed too much, right? But just every year when you're doing your tax planning or some type of yearly planning, just make sure everything is correctly done. Because if you're recently married, had a child, anything like that, things change, right? Like we just mentioned. And also make sure that those things are spelled right. So I have a space in my middle name. Guido has 2 spaces in his middle name, we have spaces in our last names, and so does Guido. And it can be an issue where if something's not spelled right, that there can be more hiccups then. So we want to make sure that there's not any type of spelling error. Well, to wrap up, our final term we're talking about are going to be gifts. And unlike many of the other asset transfer tools we talked about today, gifts, they're not an inheritance, but rather they're given with a warm hand. And that does not only does this mean that there needs to be an intent to give and acceptance of the gift, but to have a valid gift, there also has to be a valid delivery or transfer of the ownership. So gifts, they can be used as a business transfer strategy to involve the next generation in a family farm operation. You can gift land or stocks or shares of a company of a business to the next generation. So you can do it as a different type of transition strategy, inheritance strategy, but a gift can also just be that, a gift where you want to be involved in your friend, family, whoever it may be's life now and not wait and for 40, 50 years down the road to help them out. So this is more of an immediate way to transfer assets. So some of the disadvantages of gifts, well, one of those is loss of control. Once you give a gift, that asset is no longer part of under your ownership. So it is important to make sure that you have enough assets in order to take care of yourself. And you're not over giving, that you're able to still provide for your retirement or something like that. There can also be possible tax consequences, especially with capital gains. When and things like land too, that just values have skyrocketed in the last 20 years. So with that example, when land is given, the basis or the value of it for tax reasons, it stays the same as when the person who gave the gift originally had it. So with land, if someone is given land, they don't get the new basis at all on what the current market value is. So that could create an issue where someone can't sell the land or can't do much with it because the tax consequences are just so high. So currently in April 2021, you can gift up to $15,000 per year to any one person without having to file a Form 709. So you can gift over that amount. If you do, you file this Form 709 because that is part of this joint federal estate tax and the gift tax. Because like we had mentioned earlier, there's this $11.7 million lifetime exclusion. And if gifts that are over that, it will slowly start to chip away at that exclusion. So if you would go over eventually, the IRS would like to know that. And so with that, thank you so much for everyone who's watched. We really hope you guys enjoyed this, that you learned something valuable as you are working with your own lawyer or tax professional. You understand these terms a little bit better, and hopefully you feel a little bit more confident in working in this process. So, Guido, is there anything else before I let the people go?
No, I can't think of anything. And again, I just want to say thank you to the folks that did listen. As you can see in this particular slide, Kit and myself are available via email should there be any follow-up questions, and we'd be happy to help. Thank you so much.
Yep. Thanks, everyone. Have a great day.